Good afternoon, folks. My name is Gladys Puente Valentine. I am a program manager here at the California Law Pathways Program. Welcome to Constitution Day 2025, Upholding Justice, Exploring Constitutional Rights, Legal Advocacy, and Pathways to Public Service. We're so glad that you've joined us for this important conversation about constitutional protections, due process, and the role each of us can play in advancing justice. It is my honor to introduce today's moderator, Ms. Thuy T. Nguyen. Ms. Nguyen is a partner at Garcia Hernandez Sani LLP, where she practices in the firm's education, law, and equity leadership groups. Ms. Nguyen has served in different roles for California Community College System, the General Counsel for Peralta Community College District, interim CEO of the Community College League of California, interim General Counsel for the State Chancellor's Office, and in 2016, becoming the first Vietnamese American college president in the nation when she led Foothill College for more than 5 years. In 2017, Ms. Nguyen was honored as part of the Carnegie Corporation's Great Immigrants Tribute in the New York Times. The tribute is aimed at recognizing naturalized citizens who have helped advance society, culture, and the economy. Ms. Nguyen was also founding board chair of the California Law Pathways Program and continues to serve as a member of its advisory council. With that, I will pass it on to Ms. Nguyen to guide us through today's program.
Well, good afternoon. Happy Constitution, U.S. Constitution Day. It was a joy seeing many of you at last year's annual summit at Chapman Law School. And today we are talking about the United States Constitution and Cal Law Pathways. Is always very proud to be able to do programming virtually statewide on Law Day and U.S. Constitution Day. Today, as you know, is U.S. Constitution Day itself. There's a lot going on. In fact, just watching the news this morning, conversations around how the Constitution is being upheld, how the Constitution is being tested, how the Constitution is being challenged, and how the Constitution is needed more than ever. And so our work and the work of Cal Law Pathway with bringing you Constitution Day is so important. That said, there's a lot of emotion around the topic that we are talking about today. And so I'd like to do a Slido, a poll, asking everyone, if you have your cell phone, you can also go onto your laptop to the internet, slido.com, and press in the number 1787. That number is important because that was the day, the year in which the delegates signed the U.S. Constitution. So in 1 or 3 words, how do you feel about the United States Constitution as we observe Constitution Day today? So go on to Slido and enter in your sentiments. How are you feeling about the U.S. Constitution and how it's being exercised and played out today? I know our panelists are looking at this too. Some really strong words here. Still needs a lot of work. Nervous, hopeful, under attack, strong, misinterpreted, invaluable, heartbroken, foundation, reflect, unstable. Oh, wow, that the word disappointed has come up a lot. And so that's why Slido is showing that. Let's give it another 10 seconds. Thank you so much. Thank you for sharing your sentiments with me. We found it very important to just do a temperature check of where and how people feel. Today, we're going to be talking about a good number of amendments in the U.S. Constitution, two in particular, but actually there are other elements of the U.S. Constitution. And so let me do just a quick primer, meant to be very high level. The Fourth Amendment, as many of you know, is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it speaks about the need for a warrant. No warrant shall be issued upon probable cause before people are searched, seized, etc. And this is particularly important around the ICE enforcement and ICE raids. And we all know very well around probable cause. So this is the Fourth Amendment. The Fifth Amendment speaks about no person shall be compelled in any criminal cases to be a witness against himself or deprived of life, liberty, or property without due process of law. And due process speaks to Miranda rights, the right to remain silent, the right to attorney, the right to jury trial, etc. Now, many of us have heard about the Know Your Rights trainings. And in fact, I'm an education lawyer, and so I've been going to and helping colleges, community colleges and high schools have Know Your Rights and advise them around immigration issues. But many of I would always have to remind people it's not know your rights in terms of for undocumented students and mixed status families. It's actually know our rights because these rights apply to all of us, no matter immigration status. So I just want to remind people of that. The other thing to remind people is also we talk about the U.S. Constitution, but California has its own constitution. This constitutional provision specifically talks about all students and staff in high school, senior high schools, where some of you are, community colleges and the like, are have an inalienable right to attend campuses that are safe, secure, and peaceful. So know your rights, know our rights, and let's bring on our panelists because I want you to learn about, as you're studying to become a lawyer or study law itself in general, we are not talking about not just the U.S. Constitution years ago, but we're talking about the Constitution in action today. And we have two phenomenal panelists. I'm so grateful for them to take time from their busy schedule. As you can imagine, they are very busy with things that are happening right now. The first panelist I'd like to introduce and invite Mohammad Tajsar. Tajsar, a senior staff attorney at ACLU. He is doing phenomenal work. He joined the ACLU of Southern California in 2017. He serves as he's primarily a litigator. His work focuses on national security and counter-terrorism policy, as well as government surveillance and consumer privacy. He specializes in civil rights and privacy law with a focus on challenging government surveillance and protecting communities from misuse of surveillance technology. He also, his work includes high impact cases such as Fazaga versus FBI, Alderstein versus Customs and Border Protection, alongside advocacy on digital rights and consumer privacy. He currently serves as lead counsel in the Vasquez Perdomo case, which is a quintessential case right now that many are following. He will be sharing also his personal journey in the legal profession and present that case as a broader issue of immigrant rights. Mohammad, please, thank you. Please, everyone, give a virtual round of applause and welcome Mohammad to our Constitution Day.
Thank you so much, Tari. Thank you all for joining. I appreciate the opportunity to share a little bit about kind of the work I do, the work that my organization does, the work that I'm doing in conjunction with my co-panelist, Rebecca Brown over at Public Counsel, and to kind of give you just this flavor for what kind of how we perform the kind of work that we perform as lawyers and as litigators. So So perhaps we can get pull up our slide deck. I think the first thing maybe I might say is just a few things about myself, and how I came to this work. So just a couple of brief words. So I live here in Southern California, in Pasadena in particular, and I grew up in Los Angeles. And I went to school here. I am an immigrant, so I started first grade in America. And no, that's not true. I started second grade in America. Oh boy, my first grade was abroad. I started second grade here. And in second grade, I went to school in West Los Angeles in a LAUSD public elementary school, and then I've went through the LA Unified's like public school program through high school, and then after high school, I graduated, and went on to another public institution, UCLA. After that, I went to another public institution where I attended law school, which was the University of California, Berkeley. So I'm an immigrant, kind of first, not even a first generation American. I'm a zeroth generation American, and sort of a graduate of fine public institutions throughout the state of California. And kind of I kind of landed in this place. We can go on to the next slide. I landed in this place, kind of thinking about kind of wanting to be an advocate for justice in some way or shape or form. And I think what I'd like to kind of what both Rebecca and I would like to talk to, to everyone about is kind of our path to getting there, and how one way that we've become advocates for justice. And that is through this sort of concept of impact litigation. It's not everything that we do, but it's quite a bit of what we do. And then we'll talk a little bit about a case study for exactly what that looks like out in the field. So you have a sense of what being a kind of civil rights or human rights attorney looks like, and what being an impact litigator looks like. So with that, we can move on to the next slide. Excuse me. And I could talk a little bit about what I do as a lawyer, and then how I do it, and then with whom I do that work, and then maybe I could pass it along to Rebecca to answer the same questions. So, so I work at the ACLU. That's the American Civil Liberties Union. It's an organization that is committed to furthering the civil, constitutional, and human rights of people throughout the country, especially marginalized individuals who are often sort of attacked, targeted, or otherwise sort of abused by society in general and the government in particular. And my kind of way of interacting with the legal profession is that I'm primarily a litigator. And so what that means is I sue people. So being a lawyer is a pretty big category, as some of you may know. And there's lots and lots of ways to be a lawyer, and lots and lots of things that lawyers do. One of the things that lawyers do is go to court. It's in some ways the most like classic kind of form of lawyering, and that's what I do. That's called being a litigator, when you litigate cases, and so that's what I do. And in particular, the second question is like, how do I do it? Well, I typically represent individuals or organizations in cases where I sue the federal government, primarily the federal government, but other government agencies, on issues that are important to those organizations, important to communities in which people's rights have been violated, and the consequence of that lawsuit is likely to create long-lasting change. That is the kind of work that I do. And I do it in a few particular areas, but there are lots and lots of things that we at the ACLU work on, that folks at like Public Counsel work on, lots and lots of organizations work on. But that's the kind of basic premise. So what we do is litigate. How we do it is we represent individuals in court proceedings in cases where we think we can have a broad-based impact, not just on the individuals who are our clients, not just on the like in the particular case itself, but we try to establish law and precedent to make sort of long-lasting changes towards justice. And then the third question is like, well, with whom do we do it? Well, we certainly at the ACLU, and what I do is we do it in conjunction and in collaboration with lots and lots of people, lots and lots of stakeholders. So the first and most important people that we work with is our clients, people that I represent, people that we represent who have been harmed, who have been injured, who are seeking to vindicate their rights. So we represent them. But we also work, often those individuals are themselves part of organizations, parts of movements, or may not even, or have their own kind of communities, loved ones, support systems, and we work in conjunction with them. And then we also work with, excuse me, other partners, other collaborators, other organizations, other elected officials, other people who are all working together in one sort of in lockstep towards getting to the place that we want to get to in the future. So in the context, for instance, of immigrant rights, we work with our clients, but we also work with some organizations that are working on immigrant rights issues. And we also work with lots of other partners across the sort of like immigrant rights arena in working in collaboration with everyone towards building a movement for justice for immigrants throughout the country. So it is often the case that our work is really collaborative. And it's not just, us sitting like at our desks and our computers working on particular cases by ourselves, but it's thinking about how our cases fit within a much broader movement towards getting the sort of the justice and vindication of the rights that that sort of concerns us and wakes us up every morning. So that's a little bit of a preview for the kind of work that I do. There's also, I do some other stuff. About 75% of my work is litigating. I also do some work in the kind of legislative arena, so working on laws and regulations that are passed by like elected officials. And then I also do some kind of public advocacy, like working with reporters and in the media about sort of writing and about the issues that we care about and various other things. But primarily, I file lawsuits against people. So that's a little bit of an intro into like how I define kind of lawyering for justice for me. So maybe with that, I might pass it over to Rebecca.
Yeah, actually, if you don't mind, Rebecca, I'd love to introduce you to our students, our faculty, our teachers. Some are joining as watch parties from their classrooms. Why? Wow, are we lucky to have Mohammad on this call to give us not only a glimpse of how he got into law, but soon about the work that he's doing. But we are also very lucky to have another lead counsel on the Vasquez Perdomo case, and that is Rebecca Brown. She is going to talk to us about the pivotal lawsuit that is challenging the due process violations in the immigration system and advancing constitutional protections that have broad implications for immigrant communities nationwide. She is a supervising attorney with Public Counsel's Immigrants' Rights Project, really phenomenal, where she provides direct representation to LA-based immigrant communities focusing on children and families seeking humanitarian relief. In addition, Rebecca Brown, also sometimes known as Rebecca, leads and coordinates the IRP's policy advocacy and strategic litigation efforts to protect the rights of immigrants and expand the rights of all Americans. She has worked on immigrants' rights advocacy for over a decade before joining Public Counsel in 2022. She served as a DOJ accredited representative and director of operations at Central American Legal Assistance in New York City, where she assisted hundreds of DACA, TPS, and asylum applicants. She is really in the work that is so important from the big picture to also the individual clients that are benefiting from her work. Becca, if you don't mind, we also affectionately call you that. Please tell us about your own lawyering journey.
Yeah, thank you so much for having me. It really is a joy to be here. I share a lot of the words that were expressed in the Slido, but it really is just so lovely to be with you all today. And yeah, so as was mentioned, my name's Rebecca Brown. My pronouns are she, her, but my friends call me Becca, and we're all now friends. So you can call me Becca. And so yeah, I'm a supervising attorney at Public Counsel. Public Counsel is a nonprofit in Los Angeles that provides direct services to the community, as well as conducts impact litigation and policy advocacy to further whatever is needed by the community and address community need. We have 8 different projects. I'm in the Immigrants' Rights Project. So we focus on direct services to folks who are seeking humanitarian relief. So that can look like asylum. It could also look like special immigrant juvenile status, which is a special status for kids who may not have one or both of their parents to care for them. There's also protections for victims of crime and trafficking that we focus on. And so in my role, I have a small caseload of clients who are applying for one of those humanitarian benefits. And then I also get to work with people like Mohammad, and who I just am learning about, learning everything from as much as I can, and do strategic litigation to affect meaningful change and lasting change. I came into this role, I had a kind of roundabout way of getting to law school. I'm the first in my family to become a lawyer. My grandfather was a Holocaust survivor who was able to survive the Holocaust through what's called the Kinder Transport, which was a special arrangement to get a number of kids out of Czechoslovakia at the time. So I am a product of kind people looking out for children, and it had a big effect on my life. And so I couldn't afford law school. I don't know if anybody can really, but so I decided to work as a DOJ accredited rep, which is someone who's been approved to represent immigrants in immigration court, but who isn't a lawyer. So you still have to do a bunch of training, and you hope you have good supervision, but you're not a lawyer, so you can't go outside of immigration court. And I absolutely loved doing that. It was really rewarding, but I wanted to make more change. And that's what led me to law school, and led me to this work that I'm just, as difficult it is a true joy to do it. And so I can address these 3 questions a little bit. So, and I think I've covered a lot of them. And then, but with whom do we do it? Like Mohammad said, we work with the communities that have been affected and with our clients directly. And from those direct client services, we identify issues that our clients and communities are facing. So then we can take that maybe to legislation, maybe we take it to the media, maybe we take it to court. And we work in coalitions with other nonprofits and other stakeholders, like maybe a union, to file a lawsuit. And so I, like Mohammad, am primarily engaged in strategic litigation. But as I said, I also have a small docket of my own direct services cases. And those cases are often in immigration court, which is a totally different experience and is getting stranger and stranger with each day.
Becca, thank you so much. I got a little emotional as I was hearing your story. I hope you were able to see the hearts coming through the Zoom by some of our attendees for your part of the introduction. That more hearts are coming. There you see it. And Mohammad, likewise with you. But just thank you so much for bringing all of both of you bringing all of your heart and your great mind to the work. Mohammad, if I can ask you the question regarding, let's zoom into the case, right? The Vasquez Perdomo case. What is a long-term potential implication of the Supreme Court's recent ruling. Maybe you can give us a little sense of what that ruling is, what the case is all about. You're definitely lead counsel on it, along with Becca and others. If you can give us a big picture. And I also would like to invite the attendees and the classroom, even if you're in a classroom watch party, to use the question function to ask any questions of them throughout. We'll make sure that they get through what they need to say, but we definitely would love to get to your questions too. So, Mohammed?
Sure. Yeah, maybe it might be helpful to if we sort of before diving into the case a little bit, just to connect the dots a little bit and sort of
Yeah.
provide a sense of like what exactly like how that particular case can result in the outcome that we want. And perhaps what I might do is just sort of walk through like what we mean by bringing a case like Vasquez Perdomo in and hoping for a much bigger outcome than just the four corners of the potential
Oh,
litigation.
brilliant, brilliant. Love that thought. It's the strategy behind the impact litigation.
Yeah,
Let's go for it.
that would be helpful. So in that so let's talk about that a little bit. So on the next slide, I have a few questions that I think will get at exactly what our kind of sort of project is, as it were. So I want to talk a little bit. We already mentioned a little bit about like litigation, but I want to talk about what exactly the word impact means in this context, and then what are the alternatives. And then I'll talk a little bit about some examples of like impact litigation and impact litigators. And then we can talk about Vasquez Perdomo. So we've already talked about litigation and like what it means. It just means suing people, right, in courts. But what about impact? Like we've already referenced it, both Becca and I. But I think it bears repeating, that part of what we mean here is, when you represent somebody and when you're in court, you're trying to decide a dispute that you're involved in, right? So if I have a dispute with Becca, we're neighbors, and I built a fence on her property, and she's upset, and she takes me to court. She's like, "Hey, he built a fence on my property. You shouldn't do that." We'll go to court. We litigate, and the result of that case is the judge will decide where should the fence go, or like whose property was it on. That case is important, but it may not have greater impact beyond the two of us. It'll resolve our differences and we can go back to being friends, but it won't change a thing about, property rights in general. So it's not an impact case because it doesn't have really much broader impact. What we're doing there is we're just applying the law, applying property rules to that particular dispute that we've got. That's quite a bit different than the Vasquez Perdomo case and some of the work that I do and the work that Becca does. When we bring these cases, we are trying to push and advance a particular legal rule forward, not just for the clients in the case, but for everybody at large. We're trying to establish legal rules, establish precedent that is broadly applicable and helps us get towards the place that we want to get to, right? That's what we mean by impact. And that's sort of a critical job or a critical type of lawyering that exists out in the world, some examples of which I'll provide in a moment. Now, what are the alternatives? The alternatives are some of the work that Becca does, which is, handling individual cases on behalf of individuals who have been wronged in a particular way. Those cases, they might not necessarily have broad impact beyond the particular individual or their loved ones and their support systems, but they're nevertheless righteous and important. So, for instance, if a rule exists that people are entitled to benefits for like health insurance benefits if they're low income, and they're not getting them for some reason or another. And you have to go through a process to get individuals their right to health insurance paid for by the government. You would take on those individual cases. You're not changing the rules about health insurance entitlements in general. You're just allowing individuals to get the benefit that they're entitled to. So that is an example of an alternative to impact litigation. So often when we say, for instance, that there are other sort of public interest lawyers who work on who provide legal services to individuals or legal service providers, that's what that means. It means providing legal services to individuals to assist them in their individual cases and their individual lives and to kind of vindicate an existing right that they have, with the mind that it may not, that particular case may not itself have a much broader impact beyond them, but perhaps the cumulative impact of all of these individual cases establishes some basic rule or precedent going forward. That's, I think, the alternative. So before I talk about, or we talk about Vasquez Perdomo, let me give you an example of some people that you may have heard of that that have done impact litigation in this way. I'll show you 3 pictures of them in the next slide. I assume some of you know these people, and or at least a few of these images may ring a bell to you. On the top left is Thurgood Marshall. Thurgood Marshall was, in that photograph, was a sitting judge, but before that, he was an impact litigator. He worked for the NAACP Legal Defense Fund, and he was responsible for bringing some of the most seminal civil rights cases early on during the civil rights movement. He later became a Supreme Court justice. On the right is a picture of Ruth Bader Ginsburg. She too became a civil rights, a Supreme Court justice, but before that, she was an impact litigator. She worked at the ACLU and advanced gender equality in the law. On the bottom left is an individual named A.L. Weirin. He was a lawyer, worked at the ACLU, actually at the same organization, the same office that I worked at, and he was one of these like early constitutional lawyers and impact lawyers, a kind of like sort of lawyering that actually didn't really exist for until the 20th century. Like this conception of impact litigation is a relatively recent phenomenon. It didn't exist, you know, like the Constitution is old, right? The Constitution is from the late 18th century, but there wasn't really impact litigation in this way. There wasn't civil rights litigation in this way. And these 3 individuals are among the coterie of lawyers who really made that possible. And so what are the fruits of their work? If you go to the next slide, I'll show you, there's a photograph of 2 of, well, there's on this slide is a list of some organizations that do some of this work. You know, Public Counsel, the logo's there. The Public Counsel does some of this impact litigation. There are a few others that I listed here. LDF is who I referenced. That's Thurgood Marshall's organization, the NAACP Legal Defense Fund. There are others. And these are not the only ones. There are tons and tons of them all across the country, places that you all can work for one day. And if you go on to the next slide, I'll give you this is an example. I'll give you an example of 2 cases that some of these organizations worked on. So on the left is a picture of Fred Korematsu. Fred Korematsu was an activist, a Japanese American who challenged the federal government's internment of Japanese Americans during World War II. And he brought a case challenging his sort of conviction for failing to sort of appear to be relocated to a internment camp. And his case was actually a case taken on by, among other lawyers, by the ACLU, and led to a decision under his name called Korematsu, which famously is, I think, one of the widely regarded as a really destructive and one of the worst decisions issued by the United States Supreme Court, in which they found that despite the fact that he was racially discriminated against based on his identity as a Japanese American, that racial discrimination was nevertheless justified constitutionally because of the U.S. government being at war with Japan, sort of famously awful and racist decision. On the right is an individual who you all may know. I don't know actually. It's interesting because I think lots of people don't actually know who the Brown was in Brown v. Board of Education. But the gentleman on the right, his name was Oliver Brown. He was a pastor, and he was one of the plaintiffs in Brown v. Board of Education. The decision that ultimately went to the Supreme Court, actually litigated by Thurgood Marshall, and where the Supreme Court unanimously held that that the Constitution requires the end of segregation, and that requires sort of integration in public schools. He was a pastor and a welder, and he was part of a group of plaintiffs who brought that case. So these are just two examples, really seminal examples of the kinds of individuals and the lawyers who brought these cases to really vindicate people's constitutional rights and have really broad and lasting impact. So with that, I think, and I think Becca probably agrees with me, that we're in a similar posture here in terms of some of these seminal issues, these really important issues that I think rise to the level of what Fred Korematsu dealt with during World War II, and what Oliver Brown dealt with in the sort of early days of the civil rights movement and the fight for integration. We're there, but we're there for in the context of immigrant rights. And so with that, I think I can answer. we could go on, and perhaps I might actually, if it's okay, Twee, I might pass it to sort of Becca to share briefly about kind of the litigation, the Vasquez Perdomo litigation, and how it sits, and kind of what the sort of
Oh, absolutely.
where
Yeah.
the kind of like Supreme Court has come down on this particular question.
And for the record, I believe you're there. This is big. This case is big. All right, Becca, you're going to tell us how big it is.
Okay, I'm going to try. Can you go to the next slide? Oh, okay, so Vasquez Perdomo. And you can see in the photo, there's a lot of people there. When we were talking about who we work with, this photo isn't even everybody. We are a big group working on this to try and defend constitutional rights in Los Angeles. And we filed on July 2nd, 2025. If you could go to the next slide. Okay. So beginning in early June, federal immigration authorities began rounding people up in Los Angeles and the surrounding area based on their race, saying that they were suspected of immigration violations. The immigration authorities then took these people to a holding facility that is known as B18. B stands for basement. So B18 is a basement in the federal building in downtown Los Angeles. The individuals detained there were not given adequate food, a place to sleep, or access to counsel. So we sued. Next slide, please. So what did we sue about? We sued about these violations of the Constitution. And to begin a lawsuit, you file a complaint. So on July 2nd, we filed an amended complaint that was piggybacking on an action that had already been filed in the Central District that was based on the arrests of 3 individuals in Pasadena named the Pasadena 3. The expanded suit was filed on behalf of 5 individuals and 4 plaintiff organizations. And it's a class action, meaning that's going to affect a whole bunch of people. It challenges the Department of Homeland Security, which is the federal immigration enforcement arm, and other federal agencies' policies and practices in connection with the raids that we saw. More specifically, the lawsuit challenges the government's widespread racially discriminatory and suspicionless stops of people, their warrantless arrests of people without following requirements under federal law, and their detention of holding these individuals at B18 in terrible conditions and without access to an attorney. Then a bunch of cities moved to join the suit. And I've listed some of those cities there. If you could go to the next slide. So just to give you an idea of this big, wonderful group, it's Mohammad and I, so ACLU and Public Counsel, along with our esteemed colleagues. And then we also have these organizations with us, other arms of the ACLU, the Coalition for Humane Immigrants' Rights, Immigrant Defenders, the National Day Labor Organizing Network, and then we have 2 private private firms and UCI, which is, I'm sure you guys already know, and a couple other individual practitioners. You could go to the next slide. So what happened? So like I said, we filed a complaint, and then after that complaint was filed, that initiating the lawsuit, we filed these things called temporary restraining orders, which is basically to tell the government to give people who are held at B18 the opportunity to talk to lawyers, and that's based on the Fifth Amendment. And then we also filed a temporary restraining order to tell the government to stop racially profiling, rounding up people, and that's based on the Fourth Amendment. On July 11th, the court in Los Angeles granted our request and said, you can't continue to do these stops and you must give people access to counsel. Our opposing side, the government, appealed that court decision. And then it went up through the layers of the courts. So there's the district court, which first granted us, then there's the Ninth Circuit, and then there's the Supreme Court. So it went all the way to the Supreme Court. And on September 8th, unfortunately, the Supreme Court granted the stay, meaning that they sided with the government. Next slide. So before we get into our panel discussion, I just want to say that that September 8th decision didn't end the case. We are very much still litigating this case. All it did was narrowly rule on the TRO. But we have a hearing scheduled for next week. We are continuing to fight for lasting protections for Los Angeles. And we're working around the clock. I don't know, Mohammad, if you want to talk a little bit more about it.
Yeah, absolutely. I mean, I think that we are, it's kind of still early days in the litigation, and indeed, like, kind of federal litigation of this kind often takes years. And so, we filed this case in July, so it's only been a couple months. But in general, some of our cases take a long, long time. They take a long time because you have to build the facts, you have to develop the record, you have to investigate, you have to like brief issues. You got to go before the judges. You do all that stuff. Maybe you get to a trial, and then even after that, there are appeals. And then if you win the appeal or you lose the appeal, you go back down. This takes a long time. Just to give you an example, like I have one of my cases, another impact litigation case. We brought that case in. We filed it. I worked on it when I was an intern. When I was in law school in 2009, and we brought that case in 2011, and it is still going on, right? So we've been litigating it for 14 years. Now that's an unusual case, but it happens. So this case, hopefully it won't take 14 years, but it'll take, we're in it for the long term. And I think our next steps are to continue to develop to investigate what the government's been doing, develop the kind of the record on the case, and to continue to make arguments, kind of full-blown arguments about why what the government has been doing is unconstitutional and why people's rights should not be violated in the ways that Senator Becca describes. So there's quite a bit more for us to do, and that's partly why we have such a big, amazing team. So that's kind of the status of where the case is at.
Becca, Mohammad, thank you so much for this. We can put down the panel discussion slide because we're going to have a panel discussion. And that is, the U.S. Supreme Court in staying that temporary restraining order, right? So it did convey some messages, not only taking up the case, but it conveyed some messages that for some of us suggest no matter how well it's litigated at the district court level, going back, right, and going back, and at one point it'll get back up to the Supreme Court. What is the hope? That things will be different. There will be a different ruling with the Supreme Court. What's the thought process on it? For some of us who are wishing to be a little hopeful around the destiny of the case.
I'll say a little bit, and then Mohammad, please jump in. I think that, at a later stage, so for one, this decision from the Supreme Court was on the shadow docket, which is a special kind of emergency docket that's not, we didn't go to oral argument and get to, stand in front of the justices and explain and give a bunch of evidence. And so at a later date, there will be more evidence, and there will be more of a fleshing out of the facts and what has happened, and hopefully be able to answer a lot of the questions that maybe the court has.
Yeah, absolutely. I think that's right. There's one of the things that's a kind of recent trend is that there are cases, particularly high profile cases, um, uh, kind of go forward um, sort of simultaneously in multiple different courts, especially because the US Supreme Court has decided to intervene much more quickly in cases on a kind of emergency posture. So
Mm,
that process of the US Supreme Court kind of getting involved really early in a case is something we're dealing with in our case in Vasquez Perdomo, but it's a kind of common trend in kind of recent years. And what that means is you sometimes get the like early interventions from the highest court, and you have to kind of adapt and get and kind of litigate the case with that happening. It makes for um, a sort of complicated, often set of procedural kind of uh, challenges, and is the reason why that practice of the Supreme Court's early intervention in cases has been so widely criticized. But nevertheless, it's kind of what we have to deal with. So,
right, right. Shadow docket. I mean, let's just put it this way: the last 8 years with the Trump administration, some people call it 1.0, and this second Trump administration, there's just been a lot of like very different things that are coming out, right, in terms of our system. For instance, like with the shadow docket, but in addition, just interesting arguments around this and that constitutionally, like even like the naturalized citizenship case, right? The Supreme Court took it on, but it was, for lack of a better word, a little bit more on the procedural element of it in terms of the impact of that on the individuals who actually, the states that and individuals that actually filed versus a national, right? National type of ban. So it brought forth a very, but for lay people, right? You're hearing this, you're going, oh my gosh, the U.S. Supreme Court has chimed in on naturalized citizenship, has chimed in on the roving ICE raids. Is this, a doom type of environment because of the Supreme Court decision? So thank you so much for clarifying that part. Really, really appreciate that. We do have a question here. Thank you both for your hard work. Absolutely. I totally agree, Melanie. I was just wondering what it was about these particular people that get to be represented and all the other immigrants that were also detained. Hope that question makes sense.
Yeah. So there are class representatives in this case that are the particular people, but they represent everybody who's been detained. So if we get certification for the class of these people, then those other folks who were detained would be folded into the case. So they will be represented.
yeah,
Appreciate that question.
yeah, that's right. Maybe just one more kind of thought about that is that sometimes it's the case, as like lawyers and impact litigators, one of the things you have to kind of consider is, sort of bringing a case on behalf of somebody who can best represent the interests of the community at large. And a person who you think is likely to kind of both represent that community at large and also win their case in particular. So there's often in sort of developing cases, there's often some amount of strategy, and that where a lawyer thinks about like who can best bring forward a particular claim. Now, I say often, it's not always the case. Sometimes you don't have the luxury of choosing like the person who's been harmed. Like the person comes and says, "Look, this happened to me. Like, will you take my case?" And we say yes. So sometimes you can sort of fashion or craft a case how you want to bring forward the facts that you want to bring forward. Other times you don't. You sort of the bad thing happened and you have to go represent that person. So it sort of all depends and is on it. You sort of work on a case by case basis.
Actually, while we're at it, can you tell us a little bit about the named plaintiffs? Maybe a little bit of their story and what is compelling?
Sure, I could do that. So we represent 4 organizations and 5 individuals in this case. So I'll talk about the individuals themselves before I talk about the organizations.
Yeah.
there are three individuals who are the kind of that were individuals who were detained and arrested, actually not far from where I live in Pasadena, in an when they were at a bus stop, when sort of federal government agents masked arrived with guns and trucks and came and picked them up, and they were then arrested and taken away. And that includes the named plaintiff, Mr. Vasquez Perdomo. So there are three of them. There are two other individuals. One individual who was a manager at a car wash, and the same thing happened to him. He was at a car wash. He was detained, actually driven for about 20 minutes, and taken out off the premises and arrested, and then returned and dropped off back at the car wash. And then the fifth individual is an individual who was working rent space at a tow yard in East LA, and was working on his car when he heard immigration agents outside, went outside, and once he was there, a couple of agents came to him and detained him, stopped him. He protested. He said, "Hey, why are you detaining me? I'm a U.S. citizen." They didn't listen. They threw him up against the fence, twisted his arm, and detained him for about 20 minutes. So those five individuals, what they all have in common is that they're all Latino men, and they happen to be in areas where other Latinos were, and were fit a profile that the government was targeting for the immigration operations. So those are the five individuals, and then we have four organizations who we represent. One is the United Farm Workers, which is an organization that you all may know of. That's Cesar Chavez and Dolores Huerta's organization. We represent them. They represent farm workers up and down the states, some with members who have been impacted by these raids. There's another organization called the Coalition for Humane Immigrant Rights, Los Angeles, called CHIRLA, which I think Becca already mentioned. They're part of the legal team as well too. They work on a whole bunch of different issues, but in particular, the sort of human rights of immigrants in the U.S. There's a third organization called the Los Angeles Worker Center Network. They are an organization that helps organize different sort of communities of vulnerable low-wage workers across the city of Los Angeles. So here we're talking about car wash workers, garment center workers, warehouse workers, sort of low-wage individuals who they sort of help organize almost like a union and provide them basic support and assistance. And then the last organization is called Immigrant Defenders Legal Center, Law Center, I'm sorry. And they are a group of lawyers who provide legal counsel and legal assistance to immigrants who need it. So those are the four organizations. So we have both individuals who've been impacted by what's happening, and also organizations themselves.
Becca, you want to add anything to that, or you're good?
No, he covered it.
Right. Thank you, Mohammed. Thank you so much for bringing the stories, the why, the human faces, and the organizations to the forefront on that. I appreciate that very much. I also appreciate Mohammed and Becca. Despite being a panelist, you're making an effort to answer individualized questions. So the question that was asked, is there a list of these impact lawyers? And Mohammed you must type real fast, because I couldn't type that fast to be able to get all of that in. And Melanie asked, thank you both for your hard work. And that was the question that you had answered earlier. Now, one thing that was interesting, and I noticed, Becca, you're attempting to answer it, is, do we know when the Supreme Court is going to take the case? Has it gone all through the lower courts already? Now, I presume this is the Vasquez Perdomo case.
Yeah, so we don't know when that's going to happen. We have a lot of work ahead of us, if and when that does happen. But yeah, as I mentioned, there's a hearing potentially next week, and then we'll go from there. But
is there an opportunity to hear that hearing for
it's not streamed unfortunately, it is in person only, but it's open, you can come.
Great information. Thank you. I know you stated you did provide evidence in this case. However, there are specifics as to why the Supreme Court voted this way, question mark. There are lots of theories on that one, right? Especially with the shadow docket. But let me, since there are some questions related also to the case, let me go ahead and speak to that. Did not provide evidence, I think was the clarification that Angelica was trying to make. And great, thank you. Are you worried about being received on the shadow docket with its record of no record? No reasoning, no judicial rationale, etc. Let's get into the deep of the legal arguments. You can tell we got people who want to be lawyers. They want to hear how the lawyer's thinking and the legal arguments. So, Rebecca, Mohammed.
Yeah, I could take that. The answer is, are you worried? Yes, I think is the answer. I mean, I think we have been. It has happened to us. We have been subject now to the shadow docket, and Elston, you're absolutely right that there are cases that the court has decided in its shadow docket, or what it calls the sort of interim docket or the emergency docket, in which they have issued no reasoning, and they've just issued an order. There are other cases in which the court has actually issued some reasoning, and so you can sort of understand what's going on. Our case was the former. Our case, there was absolutely no reasoning, and so we couldn't tell what the majority of the Supreme Court were thinking. There was one kind of what's called a concurring opinion from Justice Brett Kavanaugh, in which he laid out his reasoning, but there's no idea. We don't know about any of the other five, maybe four justices and what they were thinking. So, so that's a problem. That's a problem for not just for us, but it's a problem for lower courts, because there's the Supreme Court issues a decision, but nobody really knows like what it means or how to interpret it. And that's been one of the criticisms. The other criticism is that even when the Supreme Court issues a reasoned decision, it does so based on a pretty limited record and on an incredibly fast timeline. So they often the reasoned decisions can be they can provide some reasoning, but the reasoning can often not be very satisfying. It is often not very well like thought out and very well like supported. And the Supreme Court doesn't have the benefit of a full-blown record, and certainly the parties themselves don't have the opportunity to fully think about what they present to the Supreme Court. So to give you an example, we had 4 days to write our Supreme Court brief, and typically you would have months where you can actually sit down, think about it, do the research, write it up. But we didn't have that time. We had 4 days, and so you can imagine it. It's not going to be your best work, and certainly it's not going to be the party's best work, and it's certainly not going to be the Supreme Court's best work. When they issue these decisions on really fast timeline. Traditionally, they never did this, but they are doing it much more these days, because we have a much more active set of Supreme Court justices who really want to get involved early on. So that's the challenge of litigating in that posture.
Lucky for us, Mohammed types fast. So
I do my best.
Just to underscore something that he said was that, of directing the lower courts, the shadow docket, because it's so brief, doesn't give guidance to lower courts. And, in this country, we follow what the Supreme Court does. And so if the Supreme Court doesn't say what it's doing, then lower courts don't know what to do. And this is happening more and more. And it's just really important, I think, to remember that for years and generations we have relied on Supreme Court precedent to kind of be the guiding light for how we have decisions that affect everyday people.
Yeah, I mean, in speaking with Cal Law students and students who are actually in law school right now studying constitution law, which is a required course in law school, I have to say they say it's a very bizarre environment and very very interesting environment for professors to be teaching, because, you know, there's always been this notion of precedent, et cetera. So there's a level of predictability, right, in terms of legal standards and concepts, and things are kind of a little more disarrayed as a result of that. Nevertheless, we are talking about the U.S. Constitution. Now, you know, Mohammed, you brought up the picture, the wonderful picture of Fred Korematsu. Fred Korematsu actually went to Castlemont High School in East Oakland, where I also graduated, not at the same time, of course. And so he's a pride and honor of this alum of Castlemont High School. But his case also brought much precedent, much consternation, as you said, Mohammed, but also folks are asking in the Zoom Zoom room chat question Q&A around could SCOTUS use SCOTUS Korematsu versus U.S. as precedent upholding race. I know you've answered that, but then there are still some other questions that, you know, still interplay the SCOTUS case. So let's talk broadly around how some of these precedent, whether it be the Muslim ban environment, whether it be Korematsu, et cetera, to interplay into the situation of, you know, the Vasquez Perdomo case.
Yeah, maybe I could do that. So that a little bit of background about Korematsu. The way that the kind of jurisprudence on racial discrimination has developed is as follows. If you are to bring a racial discrimination claim under the Constitution against the government, what you have to first say is that, you know, you have been discriminated against on the basis of your race, obviously. So that's the first step. And then once you establish that, once you establish that you've been discriminated against, then the burden shifts to the government, and the government has to justify the racial discrimination. And it has to demonstrate that it has a compelling, what in the parlance of the law, it has a compelling interest in sort of engaging in that discrimination, and the actions that it took were narrowly tailored to achieve that compelling interest. So, in other words, the government has to justify it. Now, the really black mark brought spot in the Korematsu decision was that traditionally, and it had always been the case, that if there a court found, or the Supreme Court found, racial discrimination happened, that it basically would mean that the government would be unable to prove that it needed to engage in that racial discrimination because it had a compelling interest, and that the action that it took was narrowly tailored to advance that particular interest. In other words, it'd be basically impossible for the government to justify it. That was the usual like order of things. The one exception in the sort of history of the U.S. Supreme Court's jurisprudence on race, the one exception was Korematsu. Korematsu, the court actually held it. This is racial discrimination. We are discriminating against Japanese Americans, but the government is totally justified in doing that because of the need for internment and World War II and all the rest of it. And that fact, that move, was what made that case so insidious and so horrible, is that you had a bunch of Supreme Court justices in Washington, D.C. say, actually, yeah, no big deal. You know, this is like racial, that's fine. And that black mark on the sort of jurisprudence of the Supreme Court has lingered ever since. And only in Trump v. Hawaii, it had basically been understood to be really bad and be poorly reasoned and be a sort of terrible outcome. But the Supreme Court took the opportunity, and I think what can best be described as a almost cynical ploy to build some rapport with like the American public. It took the opportunity in Trump v. Hawaii, the case on the Muslim ban, to formally declare that it was overturning Korematsu and that it was poorly reasoned. Even though everybody sort of knew like you shouldn't rely on Korematsu just because it's awful. It's like imagine like relying on Plessy v. Ferguson, or like Dred Scott. No one would do that. Just because everyone knows it was awful,
Mm.
So everybody knew that with Korematsu, but this Supreme Court said, you know what, we're not just like we're also like we don't like racial discrimination, so we're gonna overrule and formally overturn Korematsu. The irony, of course, is that in the same decision, they said actually the Muslim ban is fine. And that's not like that kind of racial discrimination or whatever is perfectly fine. So it's almost like, oh, they sort of, in that sense, that's the reason why I say it's quite cynical. Because if you actually believe what you say about racial discrimination, it would have been pretty clear that the Muslim ban violated the U.S. Constitution. So a little bit of
Very
background there.
nice. Thank you for that. Wow, that was wow, that was a class. We went to school on that one. Thank you so much, Mohammed. Becca, you want to add any further on that and just precedents of previous cases like Korematsu and the like?
I think I'll just say that in the immigration context, we have seen a growing, I'll say, deference to the president and to the executive branch of what qualifies as okay under the Constitution when it comes to immigration priorities. And because of that growing power, there's arguments for racial profiling that can come in. There's arguments for exceptions to the rule because it's an immigration issue. And yeah, so that's all I want to add on that.
Yeah, thank you so much for that. There's a question from Professor Joel Blank. Hi, Professor Joel Blank. Any thoughts as to why the court is increasing the use of the shadow document, which historically speaking was rarely used? Mohammed, you kind of hinted to this a little bit and a little bit, Becca, in terms of just how unusual, and there's been some criticism about it.
Yeah, there's been a lot of criticism, actually. There's like an extraordinary amount of criticism. And they have themselves are very conscious of that criticism and have tried to like rebut it quite forcefully. So I think there are a lot of ways you could look at what's going on with the shadow docket. I think perhaps the easiest, the most simple and explanatory way is that the Supreme Court is grabbing quite a bit of power. And it very much sees itself as has an aggrandized sense of itself and wants to wade in on the big kind of political issues of the day. And as a result, is increasingly active in litigation that concerns the big sort of political issues of the day and does not want to wait to get involved and wants to actively be involved. And so that I think is fundamentally what's happening is that it is essentially a judicial power grab and a way of demonstrating that it is not going to simply stand back as like an impartial sort of like distant and disinterested body sort of overseeing the implementation of the U.S. Constitution. It's going to actively like police the conduct of the judiciary across the country in those high profile cases. So it has invited parties, litigants, particularly the government, to come to it quickly, and it has said that we will resolve these disputes fast, and we're going to do it because the issues are weighty. And so, to my mind, that is that is only explained by kind of by politics, sort of by political interests. Now, what do they say? Like, if I want to be fair, they say, no, that's not what's happening here. The reason why we're getting involved is because we need to get involved for a couple of reasons. One, there's been a lot of judicial decision making that has provided immediate and preliminary relief, often against the government, from intrepid lawyers who are bringing cases, people like the ACLU, they bring cases against the government, then they secure injunctions, preliminary injunctions, TROs, the rest of it, and stop wholesale programs and policies and statutes and laws that the federal government and governments are implementing, and the courts are like going along with the ACLUs of the world. And so the courts are the lower courts are messing it up. They're getting involved when they shouldn't. And we as the Supreme Court are coming in and putting a halt to that and saying, no, you gotta proceed normally. We're getting involved because the courts are abusing their role. The lower courts are abusing the role. That's what the Supreme Court says. I think there are lots and lots of problems with this response. But one of the problems with this response is that if you actually look at the track record of what the U.S. Supreme Court has done in its shadow docket cases, you can predict almost exactly what they will do based on the politics of the litigants. Like something, I forget the exact statistics, but there might have been thus far this year, something like 34, 35 emergency applications to the U.S. Supreme Court involving the Trump administration. It has lost 2 of them and has won all of the rest of them. So it's like pretty clear what's actually happening. And it's happening because this Supreme Court is very keen on a particular political position that is consistent with the how should I put it mildly, with a conservative outlook on some of the decisions that are coming before it. So that's one kind of set of responses, but there are others.
Yeah, and just to add to that, I saw in the chat the idea of, the constitutional crisis. And I think like what Mohammed's touched upon is, the push and pull between our 3 branches of government. And sometimes one has more power and then the other ones are meant to grab it back. But right now, there seems to be a lot of pull from the Supreme Court and from the executive. And so if Congress brings them back, we'll see. But that's kind of, to me, the constitutional crisis is one branch should not have more power than the others. They're meant to provide checks and balances. So I think that is to me a big part of it. And then I just wanted to provide this little tidbit that I learned recently. Around the grounds of the Supreme Court are tortoises, like sculptures of them, because the court has found in its years and years of existence that it needs to take its time so that it can provide reasoned decisions and provide some sort of normalcy and stability for the country. So I thought that was really interesting.
Yeah. Thank you for mentioning that. And thank you, Becca, for also typing real fast to get people information about when the hearing will take place. If anyone does come and see Becca and Mohammed, please make sure to come up and let them know that you watched this webinar and appreciate all that they are bringing forth on the matter. There is no doubt, and thank you, Becca, for mentioning the comment by Elstein Stevenson around the constitutional crisis. Our last statewide webinar for the Cal Law Pathway on Law Day, May 1st, that was actually our discussion because of the wear and tear that is going on, and with the 3 branches of government, where the judiciary is standing, and the confidence that people are having or lack thereof around our judiciary, and particularly the U.S. Supreme Court with various issues around ethics and disclosure of ethical gifts and so forth like that. So there's just been a lot around just where our courts are, period, in general. And so that's why we did some programming on Law Day. I think it may be apropos for our next Law Day to continue to weigh in on that concept around our 3 branches of a government, and particularly our judiciary, since that we are, as lawyers, officers of the courts, right? And so we very much care very much around how our courts are holding up, so to speak, in making our Constitution live and meaningful. There's a question or comment in the room in terms of how does the power grab dynamic relate to the concept of legislating from the bench, right? So, you know, the criticism can go both ways, right? Around this whole notion of legislating from the bench, right? In fact, that's what impact litigation is, right? It's to create law, so to speak, say standards of law that another way could have been achieved through a legislative fix, like going through Congress, getting law, a piece of law, or like with the state legislature, et cetera. So, but nevertheless, it is a comment. So if you can comment on that in terms of legislating from the bench.
I wrote a quick little answer to this. I think they're related, but it's somewhat different. So, you know, legislating from the bench, or that critique, which used to be in vogue, was one in which people accused judges of not of doing something they're not supposed to be doing. So, if judges are supposed to interpret the law and apply the law to set a certain set of facts, they're not, the critique goes, supposed to be creating law or writing new laws or sort of changing what the law is. They're supposed to say they're supposed to sort of say what the law is and apply it to a set of facts. So that's the critique about legislating from the bench. I think the critique that I raised about the shadow docket is a little bit different in the sense that it's about the judiciary. It's about the Supreme Court having a sort of getting involved in cases too early, or to not for sort of changing the procedures for how they get involved in cases. Not necessarily that they are getting involved in cases where they will ultimately never actually resolve. That's, I think, a little bit different, but they're related critiques, because I think part of the problem with the shadow docket is that they're getting involved procedurally in a way that is improper, or that, so the critique goes, not that they're getting involved in cases that they shouldn't get involved in at all. And so that's a little bit of a different thing. Now, to be sure, that question of legislating from the bench, that is as a separate critique of this particular Supreme Court that exists. And I think there's a lot to say for that critique as well too. But that is a critique in some ways that's as old as time. You know, when I was in law school, people said that about the previous Supreme Court, and that's what the people said of the sort of the civil rights era, the Supreme Court, the Warren Court. You know, where highlighted by Warren and Justice Thurgood Marshall, that they were just legislating for the bench, and they issued like Roe v. Wade and Brown v. Board and all these other things, and they were just making stuff up, and none of that existed in the Constitution. So that critique has been one that it has existed for quite a long time. This shadow docket thing is an entirely new phenomenon.
Right, because it's not really, if in fact we wish there was some details and ruling and thought process and evidentiary hearing and so forth like that, right? Hearing of evidence, etc. But it just took it up on a procedural level and did it in such a quiet and quick way. It's definitely not the tortoise, kind of slow, deliberate, thoughtful kind of environment, right? So thank you for that very nuanced but very apropos distinction of that legislating from the bench versus a general, I mean, like even Brown v. Board of Education, incredible amount of evidence and hearing, et cetera, before any decision was actually made, versus in the situation of the shadow docket. So appreciate that. So well, that was brilliantly nuanced to us. So appreciate that, and appreciate, of course, all the questions that are coming forward. You know, we are hearing a lot, being in California. It almost seems like sometimes it's California versus the United States right now with regards to the Trump administration. Our Attorney General has been involved on a number of matters, and of course, our governor has also spoken on a few matters too. That said, more than a few matters. That said, how are you interacting, if at all, with the state attorney general's office? Because obviously, much of the representation, the clients, the organization, granted they are national, some statewide, et cetera. There seems to be a lot of attention, obvious in LA, but clearly the raids in a maybe more quiet way is also happening in Northern California, et cetera. just how, is there any interaction with the state AG's office, et cetera, and even consideration of things that are happening in Northern California or even in Central?
Yeah, I could take that. Yes is yes and yes is the answer. There is some so we've been in conversations with the Attorney General's office. They have been they've filed what's called amicus curiae briefs in our case. So they filed friend of the court briefs in support of our position. And so they have been involved in the litigation. In terms of kind of the widespread nature of these immigration raids, you know, we at the ACLU we had filed a predecessor case to Vasquez Perdomo. It's a case called UFW, United Farm Workers versus Noem, challenging a similar set of raids and practices that occurred over a smaller time frame that were kind of vehicular stops of brown folks in the Central Valley. And we were able to secure a preliminary injunction in that case. That case is on appeal. And so there's been kind of litigation you know, up and down the state about this particular issue. We're involved in it, others are as well too. And then I also there's also been kind of litigation nationwide about some of these same practices. So for instance, I think just today, right? Today, Becca, there was a decision, an injunction that was issued in a where is it? In a case out of the Southern District of New York concerning ICE detentions in New York City.
Yeah, that was last night. It's
That was
very
last night.
similar facility to B18. So
Perfect.
yeah, and just to add to that, so yeah, I mean, we are coordinating and talking to folks from around the country about what we're seeing, how it's affecting folks and what we can do about it. But also I just wanted to flag a particular case called San Francisco versus Trump, which is the California cities that are fighting to protect their local laws. And that's another thing that we don't have time, I don't think today, to get into, but of the way that this push and pull happens, right? We've got the push and pull between the three branches, but we also have the push and pull between the feds and the states. And there's a lot of different things going on, and that case is particularly interesting, and we'll see how it goes. But and cities from around the country have joined that one.
Oh, absolutely. I mean, the U.S. Constitution as a whole, right? We have all these individual rights with the amendments, the various amendments, but then we also have the dynamic of the three branches of government, along with the dynamics of federalism versus statehood rights, et cetera. So the Constitution, it has just so many elements of it. We chose this because we know many of our students are very interested in what's going on with the ICE raids and seeing the U.S. Constitution coming alive. I, as an education lawyer, very much monitoring a lot around the federal funding, around diversity, equity, inclusion types of cases. One thing that's very interesting that I've noticed is the various injunctions that have been won to stop the Trump administration in implementing some of its various edicts, guidance, et cetera. Is that the lower courts, it doesn't matter whether it is a Republican or a Democrat appointed judge, there seems to be an amount of even keelness around it. So it's less, for lack of a better word, political dynamic. You really see just the black robe, right? And not necessarily who's appointed behind the black robe. It does feel a little different, obviously, with the U.S. Supreme Court. And that dynamic is almost, unfortunately, or for some, predictable. So thank you, Professor Joe Blank, for making note of that. That said, any final thoughts, Mohammad and Rebecca, as we come to can you believe it? This is fascinating in so many ways, but our time is almost up. So with that said, Becca, would you like to have some lasting thoughts for our students as they think about the practice of law, want to be more like Becca when they practice? Any final thoughts in general?
Yeah, sure. Just again, it's been such a treat to be with you all, and I think my little bit of advice, if I could give any, to be so bold, is to stay kind to one another. You never know who you're going to work with down the road. This is a people business. You work with a lot of different, people, and to just remember to stay kind to one another, especially when stuff gets hard. And then also to stay curious, because you got to question everything. Things can go, I didn't know what the shadow docket was when I first started looking into law school, and you just are going to learn so much, and there's a lot of different ways to plug in. So if you have any questions, my door's open about how to get into the legal profession is incredibly rewarding, even in these times. And I think that, so thanks again.
Oh, thank you so much, Becca. I hope you saw all the thumbs up, the hearts, the claps that are coming your way. Mohammed?
Yeah, just echoing those words. And I think the final thing I'd say is like these are challenging sort of times, to be sure. And it seems like, people are, asking the question of whether like why does it matter? Like what's like why be a lawyer? Like the law seems to not matter. The Supreme Court seems to just do whatever it wants, or like that's the sort of critique anyway. The Trump administration like doesn't really care about the law. Like nothing matters. Everything's made up, And I'm not one to disagree necessarily with some of those critiques. I will say though that the best way I find to provide myself with the motivation to persist in these sort of enduring fights of today is to read up on how people dealt with these fights in the past. And then I think it often is the case that nothing is really truly unprecedented. That even though the crises of today feel like they're overwhelming, so too did the crises of kind of the past feel overwhelming and felt unprecedented. And yet people persevered. They did what they needed to do. They organized, they fought, they resisted, they figured it out, and they managed. People are resilient. And I think the like in never-ending sort of demand for justice is one that cannot be kind of extinguished quickly, and it and cannot be one that is sort of kind of undermined, with like one person or one administration or one set of actors. Like nothing can really sort of put that sort of demand to bed. There's a sort of famous saying that has been attributed to a Greek poet who once described this feeling or this kind of sort of sentiment in the following ways. When thinking about those who would do harm to these particular movements, the poet said, that they came to bury us, but they didn't realize that we were seeds. And I think that sort of enduring sort of thought, that enduring kind of vision of yourself as not walking into your own like graveyard at the hands of those who would do you harm, but instead as walking into something that will become an orchard, where your kids and your kids' kids will play. I think that is the sort of feeling that I think all of us should take away from, certainly from this conversation, but also from like what's going on in sort of today's America. So
thank you so much for that. Oh, wow. I am moved. As a lawyer, I'm always appreciative of other lawyers who are in the fight, fighting the good work, representing the good people. Thank you so much for reminding us around the seed of hope, but also the kindness that we need to treat each other. Before I send it back to our Cal Law Pathways, just 3 thoughts. One is I made the mistake of saying that the judges with the court at the last law day, that was actually the year before, because we were already having conversations around the concerns with the U.S. Supreme Court. But that said, last law day, i.e. this year, law day, May 1st, we featured Sergio Garcia, who was an undocumented individual in California who became a lawyer and challenged the case so that he could become a licensed attorney in California while being undocumented. So I hope that also gives our students, many who may be mixed status or themselves undocumented, to feel the hope of their prospects. The other is that, and this is something that I say when I do my trainings on immigration rights, is to tell our students not just learn the law, but as it relates to you, but learn the law in a deep way so that you know when a Supreme Court makes a decision around a procedural matter or a shadow document, you know that that does not end the case, et cetera, et cetera. But, you know, for all those reasons that no, birthright citizenship has not been eliminated as a result of the Supreme Court decision on a procedural level, et cetera. So just really knowing that so that you are not easily scared and easily receive false information, I think is also very critical. So empower yourself. And lastly, as we celebrate, observe our U.S. Constitution and Constitution Day, you know, the story is on September 17th, 1787, when the delegates were, you know, doing in the Constitutional Convention, and Benjamin Franklin was found leaving the convention, and a woman came up to him and said, you know, so what do we have? What kind of constitution? What do we have? And what type of government are we going to have with this U.S. Constitution? And Benjamin Franklin said, a republic, if you can keep it. And this is what we are all challenged to do, even as today. Can we keep it? Can we keep the promises of the U.S. Constitution with this background, we the people, to form a more perfect union? So with that said, Gladys, Michelle, thank you so much for organizing us. Any last words? And we will end our time together.
Wow, well, let's give our speakers a virtual round of applause. Thank you so much. This was very educational, informative, but also inspiring, which I think is just so important during these challenging times, and especially for our students that are interested in law. So thank you so much. So first of all, special thank you to our very own Cal Law Pathways Advisory Council member, Twee, education lawyer, for skillfully moderating and guiding today's important conversation and thoughtfully engaging our students, our guest speakers. We love to see all those questions in the chat. That, you know, this program is for you, so thank you for engaging with our speakers. We'd also like to give gratitude to Mohammad and Rebecca for sharing your own, you know, personal journeys into law, the incredible work that you're doing through impact litigation, immigrant community advocacy and direct services, connecting your work to previous civil rights leaders. Your efforts go beyond lawyering. They embody justice-centered advocacy, coalition building, community engagement that helps change the history for the betterment for our communities. And that's exactly the kind of impact that we're striving for. And just want to thank all of our students and partners also for joining today and engaging in today's Constitution Day program and conversation. Definitely continue to learn about the Constitution and how we can work to vindicate the principles it stands for. By doing so, you're helping to strengthen your own, strengthen the rights within your community and also strengthen our democracy at large. Wanted to let you know that we have several programs coming up, so definitely go to our website. We dropped the information in the chat box. We have several events coming up for community college students, high school students, also four-year students interested in law. Many of you are already Cal Law Pathway students, but if you're not, and this might be your first event, check out the program at your local school, your campus. Send us a message. We want to get you plugged in. This fall, we have several application workshops. So if you need any support applying to the four-year universities or even law school, we have those events coming up. So make sure to go onto our website and stay engaged. So just on behalf of the Cal Law Pathways network and community, we appreciate your participation today and look forward to seeing you at future events. Have a wonderful day, everyone.
Have a good school year, everyone. Bye.